By morning, the legal world had absorbed what happened overnight. Former prosecutors, defense attorneys, law professors, they weren't debating whether the order was dramatic. They were dissecting what it meant procedurally. Because judges do not accelerate like that unless they have already built the internal record to justify acceleration. They do not compress deadlines into days unless they have concluded that delay itself has become part of the harm. And that's where this becomes more than just another skirmish in a long-running legal saga. The Trump legal strategy, for decades, has relied on time as a weapon. Stretch it. Exhaust the other side. Force settlements. Force fatigue. Force recalculation. Time has been the insulation. Time has been the moat around the castle. But what happens when the judge takes time off the table? That's the position the Trump team is now staring at. Because the compliance deadline attached to that midnight order is not symbolic. It is enforceable. And enforcement in federal court does not arrive in the form of press releases. It arrives in the form of contempt findings, monetary sanctions, evidentiary penalties, and in extreme cases, referrals that escalate beyond the courtroom itself. The first internal question inside the Trump operation wasn't political, it was tactical. What exactly must be turned over? How quickly can it be gathered? What privilege claims survive under the judge's narrowed standard? What communications, once shielded, now face exposure? And here's where the pressure compounds. The Trump legal apparatus is not a single unified team handling a single isolated case. It is a network of overlapping defenses across jurisdictions, federal, state, civil, criminal. When one judge tightens the screws in one venue, the ripple hits all the others. Documents disclosed in one matter can surface in another. Testimony compelled in one proceeding can shape leverage elsewhere. It is a web. And a web under tension transmits force across every strand. Now, add to that the political dimension. Because Donald Trump is not just a litigant. He is a candidate, a former president, a dominant political figure whose campaign thrives on confrontation. Every legal development becomes messaging fuel. Every ruling becomes an opportunity to frame persecution. That strategy has been extraordinarily effective at raising money and consolidating loyalty. But there's a distinction that becomes critical at this stage. What works politically does not always work legally. Judges do not respond to rallies. They respond to compliance. And the midnight order suggests that this particular judge has concluded that rhetorical escalation is not a substitute for procedural obedience. So the Trump camp is walking a tightrope. If they comply fully and quietly, they risk deflating the persecution narrative. If they escalate publicly, they risk antagonizing a judge who has already shown a willingness to move swiftly. If they partially comply, they gamble on whether the court will accept half measures or treat them as further defiant. Every option carries cost. Meanwhile, enforcement clocks in other arenas are still ticking. Letitia James, who has already secured a substantial civil fraud judgment, is not pausing her machinery because another judge acted at midnight. Asset valuations, bond requirements, compliance audits, those processes run on their own tracks. The more bandwidth consumed by one emergency, the less available for resisting another. And here is something legal veterans understand instinctively. Cumulative pressure matters. A single case can be managed. 2 cases can be coordinated. But multiple simultaneous accelerations across forums? That becomes a stress test not just of legal theory, but of organizational stamina. Lawyers burn out. Funds deplete. Strategy fragments. And what the midnight order did, more than anything else, was accelerate tempo. Tempo in litigation changes everything. When the rhythm speeds up, mistakes happen. Oversights slip through. Arguments that might have been polished over weeks are drafted in hours. And judges who sense vulnerability often lean into it. There's also the appeals question. Yes, the Trump team can seek an emergency stay. Yes, appellate courts sometimes intervene. But emergency relief requires showing immediate, irreparable harm and a likelihood of success on the merits. That is not a casual threshold. And appeals courts are often reluctant to micromanage trial judges who have built detailed records of frustration. If an appeal fails or fails to arrive before the deadline, the optics shift further. The narrative becomes not persecution, but procedural defeat. And optics, while not dispositive in court, shape the broader environment in which all of this unfolds. Because beyond the legal filings, there is a country watching. Supporters see a man under siege. Critics see accountability long delayed. Independents, the voters who often decide elections, see chaos. And chaos, politically, is a double-edged sword. It energizes a base, It unsettles the middle. Campaign strategists know this. They are calculating whether constant legal emergencies strengthen the brand of defiance or erode the image of stability. They are weighing whether voters exhausted by years of institutional conflict want more confrontation or a respite from it. Those calculations do not happen in press conferences. They happen in private strategy rooms with polling memos and donor calls and electoral maps spread across tables. And overlaying all of that is the judge. Because at the center of this storm is a person in chambers who has already demonstrated one thing clearly: hesitation is over. Judges do not enjoy issuing midnight orders. It is disruptive. It invites scrutiny. It raises stakes. So when they do it, it is because they have concluded that ordinary sequencing has failed. And once that conclusion is reached, it is rarely reversed casually. The next 72 hours, as we said, are pivotal. Compliance filings will be parsed, line by line. Every redaction examined, every privilege assertion tested against the new standard. If the response satisfies the court, the immediate crisis may stabilize, though the broader siege remains. If it does not, escalation becomes not a political metaphor, but a procedural reality. Contempt hearings, monetary penalties, expanded disclosure, potential referrals. Those are not headlines. Those are mechanisms. And here is the deeper significance of all this. For decades, Donald Trump operated within a system that often blinked first. Prosecutors hesitated, plaintiffs settled, banks renegotiated. The calculation repeatedly came out in his favor. What we are seeing now may be the moment the calculation flips, not because of ideology, not because of partisanship, but because institutional patience has limits. And once those limits are reached, the response can be swift. The midnight order is evidence of a system asserting its timeline over his. That does not mean the outcome is predetermined. Appeals can succeed. Political dynamics can shift. Voters can render their own verdict independent of courtrooms. But it does mean something fundamental has changed in pace and posture. The fortress analogy that opened this story, it's still useful. Fortresses are not toppled in a single strike. They erode. Walls crack. Gates strain. Defenders reposition. And sometimes the decisive moment is not a battering ram at the front door, but a quiet breach discovered too late to pass. This order may not be the breach that ends it, but it is undeniably a breach. And the Trump camp knows it. Because behind the public bravado, behind the fundraising emails and the rally speeches, there are lawyers working through the night calculating exposure. There are advisors assessing whether escalation helps or harms. There are strategists weighing the electoral cost of perpetual litigation. This is no longer about whether Trump is untouchable. It is about whether the system has decided that untouchable is no longer an option. When historians eventually write this chapter, and they will, they may not focus on every filing or every motion, but they will note the shift in tempo. They will note the moment a judge chose midnight over morning. They will note the language that replaced patience with urgency. Because timing in law, as in politics, reveals intent. The deadline is approaching. The filing will arrive. The judge will read it carefully. And whatever comes next will not be improvisation. It will be the product of months of observation crystallized into action. Stay attentive to the filings. Ignore the noise. Watch the procedural moves. That's where the real story unfolds. Because this is not over. Not procedurally. Not politically. Not historically. The midnight order was not the end. It was the system saying very clearly that the waiting is done. Because after the emergency motions are filed, after the late-night strategy calls taper off, after the fundraising emails blast out, and the cable segments cycle through their predictable panels, there is a quieter phase that follows any institutional confrontation. It is the phase where power is tested not in theory, but in execution. What happens when a former president collides not with a headline, not with an opponent, but with process? The filings that came in response to that midnight order were not theatrical documents. They were technical, dense, carefully worded. You could almost feel the tension between compliance and resistance embedded in the language. Assertions of privilege carefully hedged. Disclosures measured, but not expansive. It was the legal equivalent of inching forward while keeping one foot braced behind you. And that posture tells its own story. Because for years, Donald Trump's public brand has thrived on maximalism, total victory, total exoneration, absolute language. But the courtroom is allergic to absolutes. It runs on standards, burdens, thresholds. It does not reward defiance for its own sake. It demands structured argument. The judge, in reviewing the response, is not reading for tone. She is reading for completeness, for sincerity of effort, for adherence to the letter of the directive. And if there is one thing judges are acutely sensitive to, it is whether they are being tested. This is the dynamic now in play. Not a dramatic standoff with raised voices, but a subtler contest. Is the court's authority acknowledged, or is it being maneuvered around? And here is where the broader implications stretch beyond a single litigant. The American legal system rests on a quiet premise that even the most powerful individuals ultimately submit to procedural rules, not because they agree with every ruling, not because they like every outcome, but because the alternative is something far more destabilizing, a hierarchy of compliance based on status. If one category of citizen can treat court orders as suggestions, the system fractures. That is the backdrop against which this judge operates. Not partisan calculation, not cable chatter, institutional continuity. And so the evaluation is deliberate. Each submission examined. Each claim weighed against precedent. Each omission considered not just as an oversight, but as a potential signal. If the court determines the response meets the standard, the immediate temperature cools. The narrative shifts from crisis to compliance. The legal machine continues forward on its tracks. Deadlines reset. Discovery proceeds. The case advances incrementally, as most cases do. But if the court determines the response falls short, if it appears evasive, incomplete, strategically narrow, then escalation becomes almost inevitable. And escalation in this context does not mean rhetoric. It means orders with sharper teeth, financial penalties that accumulate daily, adverse inferences that shape the evidentiary landscape, in extreme circumstances, findings that carry reputational consequences far beyond the courtroom walls. This is why the coming days matter so profoundly, because what we are witnessing is not simply another chapter in an ongoing saga. It is a test of a long-standing theory that delay and volume can outpace accountability. For decades, Trump's approach to litigation operated on a principle of saturation. Countersue, appeal, delay, reframe, challenge jurisdiction, challenge standing, challenge timing, create so many moving parts that momentum diffuses. And often that approach worked. But the current legal environment is different. Multiple courts, multiple jurisdictions, judges who are acutely aware of the broader context, a public that has been conditioned to expect conflict, but not necessarily immune to fatigue. There is another variable here that cannot be ignored: political timing. An election cycle compresses everything. Court calendars intersect with campaign calendars, depositions compete with rallies, hearings overlap with primaries. The optics of a candidate navigating both arenas simultaneously create a kind of split-screen reality. On one side, speeches about strength and dominance. On the other, filings about compliance and deadline. That tension is not easily resolved. Campaign advisors understand that voters do not follow procedural nuance. They respond to tone and trajectory. If the legal narrative appears chaotic, if penalties mount, if judges issue increasingly stern rebukes, the image of control begins to erode, not necessarily among the most loyal supporters, but among those who equate leadership with steadiness. And steadiness is the commodity most endangered when litigation accelerates. Meanwhile, prosecutors and opposing counsel operate on a different clock. They are not measuring applause lines. They are measuring leverage. Each court victory, even a small procedural one, compounds. Each enforced deadline narrows maneuvering room. Each disclosure opens new lines of inquiry. It is cumulative. And cumulative pressure changes decision-making. There is always a point in protracted legal battles where strategy shifts from expansion to containment, where the goal becomes minimizing damage rather than asserting dominance. The question hovering over this moment is whether that shift is underway. If it is, it will not be announced publicly. It will reveal itself subtly. A softer tone in filings, fewer sweeping public claims, more emphasis on procedural fairness than total exoneration. These are the tells seasoned observers watch for. But there is also the possibility that confrontation intensifies, that appeals are filed aggressively, that compliance disputes become their own battleground, that every adverse ruling is framed as institutional overreach. That path carries risks of its own. Judges are human, but they are not swayed by spectacle. They are often galvanized by it. And so we return to the core question. What does it mean when the system appears to say, enough? Not enough politically, not enough rhetorically, enough procedurally. It means deadlines matter again. It means defiance has consequences. It means the assumption of endless elasticity in the timeline no longer holds. And that realization, more than any single ruling, is destabilizing. Because if time can no longer be stretched indefinitely, strategy must compress. Decisions must be made faster. Resources must be allocated more carefully. Priorities must be set. Which case takes precedence? Which appeal is worth the gamble? Which disclosure can be conceded without cascading harm? These are not abstract dilemmas. They are the daily calculations of high-stakes litigation. For the public, the spectacle may feel repetitive. Another ruling, another filing, another round of punditry. But beneath that surface repetition, structural shifts are occurring. Institutional patience, once extended, has limits. And when those limits are reached, enforcement replaces warning. The midnight order signaled that warning had passed. The response to that order and the court's reaction to the response will determine whether this becomes a stabilizing moment or a spiral. If compliance satisfies the court, the temperature drops. The process resumes its steady march. The broader political debate continues on its own axis. If compliance falters, the spiral tightens. And in that tightening, something larger is clarified. The American system does not move quickly by default. It is cautious, layered, appeal-friendly. It bends over backward to ensure fairness, to provide opportunity for argument, to allow correction. But when it moves decisively, it does so with accumulated weight. That is what we may be witnessing now, accumulated weight finally shifting. Not a single dramatic collapse, not a cinematic downfall, but a structural recalibration in which the rules reassert themselves. And whether one views that as overdue accountability or as aggressive prosecution, the fact remains, the contest has entered a new phase. The old playbook delay, diffuse, dominate the narrative may no longer be sufficient. Now the focus is narrower, specific, procedural. Did the order get obeyed? Did the disclosures meet the standard? Did the court's authority hold? Those are the questions that matter. Because beyond the headlines, beyond the partisan framing, beyond the fundraising emails and the campaign speeches, there is a quieter verdict unfolding. A verdict about whether institutions still function when tested by power. We are watching that test in real time. The filings will continue. The appeals will come. The speeches will not stop. But beneath all of it, the machinery of the court is turning, steady and indifferent to spectacle. And that machinery, once engaged at full force, is difficult to slow. This story is not about one order or one candidate or one election. It is about the tension between personality and process, between dominance and discipline, between narrative control and legal obligation. And in that tension, something fundamental is being decided. Not in a rally, not in a poll, not in a cable segment. In a courtroom where the clock has started ticking, and this time, it is not clear that it can be stopped.